Sorry about this, folks. I'm streaming in 3G. Hi, Thorin.
Make sure that great job today. Just this front area right here. Don't let anyone sit in this front area right here. We're saving this for other people. Yeah, that's an important area. Thank you.
So you can see folks are beginning to file in. Hope this quality is optimal for you. So we're waiting for the panel to begin. With Freedom 7, Chris Hedges and Michael Moore over this NDAA. Yeah, I'm live right now. Live in 3G. We hate those two letters together, or that number and that letter together, but we have to make do. But that's why we have the camera in the front over there. Hopefully everyone out there in streamer land is doing well. You can see the lights are being adjusted at this time.
You want to put in there?
Anyway, last year I done Occupy, it's one of the screens. Are you using a specific version?
Stop NDAA.
Okay.
My quality,
I mean, I think it would be...
just pre-warn them that I'm using 3G.
I mean, I'm going to flash all three of you, and it's like, depending on whatever it is the viewers will decide which one.
Yeah, I'm streaming at 3G. I don't have a good connection in here.
So you don't want me to promote you?
No, do promote me. Just let it be known I'm in 3G.
Okay. Might be streaming it, but don't look at it. So Matt, are you using a specific version?
If my social stream is lagging, I apologize.
What?
Oh, yeah.
I think it's a bit dark in here. What do you think?
I'm logging in 3G, right, or no? I don't even have 3G. I'm leaving.
What?
I'm leaving.
You're leaving?
Yeah. I'm not just saying stupid. I mean, look at white people on the fucking panel talking to more white people about white people issues. And then the only black fucking journalists, they squawk for coming in fucking streams. They don't need those fucking credit. I'm trying to find out the Wi-Fi. Huh?
Are you keeping this thing here, though?
I'm taking my shit.
Well,
Wasn't welcome.
You know what? That'd be a great future interview. Your thoughts about
I have no. I even like fucking people on the panel. Fucking fuck you. I always felt really good about this place. I always say really nice things about this place.
By the way, I want to talk to you about an idea that I'm having soon. I threw it across some folks at DC Media Group. They seem to be down with it, so I'll throw my idea your way too.
Stop by later.
You're right down the street, right?
Yeah, I'm right around the corner.
Yeah. I'll stop by later.
Matt, you're gonna like yes.
No, please, no. Oh my God.
Hi, so if everyone's ready, we'll kick off tonight. We have a lot of people to listen to. This is the first of two panels addressing the lawsuit, Hedges versus Obama, which was back in federal court today, looking at fighting the indefinite detention provision 1021B2. My name's Natasha Leonard. I'm a writer with Salon.com. I'm going to be co-moderating with Matt Sledge from Huffington Post. And let's get rolling. I'm going to introduce our first panelists, who are going to focus on the legislation and the legal effort that's been ongoing since Mr. Hedges first filed in early 2012. Far left, right is your facing that way. We have journalist and social activist Alexa O'Brien.
Take a picture of the panel.
Do you need a picture?
Of the panel.
Then we have Mr. Colin Mayer, and next to him, Mr. Bruce Asprin, who are the two attorneys leading the plaintiffs in their battle to defeat the indefinite detention provision. Of course, we have James, decision theorist, probably better known to you as Pentagon Papers whistleblower, Mr. Daniel Ellsberg. Is the lead plaintiff in the case. Then we have Mr. Chris Hedges, and the namesake of the case. Then we have Ms. Tangerine Boland, who is the co-founder and executive director of Revolution Truth, who work on transparency and whistleblower protection, and also has done so much work bringing plaintiffs together, herself among them, to add real clout to Mr. Hedges' initial filing.
And then to the left of Tangerine, we have David Siegel, the executive director of the advocacy group Demand Progress, which he co-founded with Aaron Swartz, and my former city councilman and then state representative in Rhode Island. So we're going to let Tangerine lead off and direct some questions to our panelists, and then hopefully we will open it all up if we have time to you, the audience. So share cheers, boos, whistles, and questions for that period, if you can. And Tangerine.
Thank you very much to both of you. Thank you everyone for being here this evening. This is very exciting. My first question is, how many people, I guess I can't see your hands, but maybe give a shout if you were in court this morning or tried to be in court this morning. That is awesome and excellent. Thank you so much for coming. And, you know, I'm so sorry to those of you who couldn't get in or who had to deal with terrible auditory issues, a few things that were not foreseeable for us, and we did our best. And your presence mattered there. That was a key part of the strategy of this case, so thank you for coming this morning. I wear a lot of hats here, so I'm going to try to get through this quickly so we can just get on to the conversation. But just some housekeeping stuff. We have a very quick intermission, 5 minutes. We need you to keep to that. And so first of all, a big thank you to our team, to our lawyers, to Dan Ellsberg and Noam Chomsky, who can't be here today, Chris Hedges, of course, Demand Progress, and co-sponsors, BMRDC, my organization, Revolution Truth, the Culture Project, and the NYCLU. So thank you to all of our sponsors. And just to give a quick introduction, this has been a long road for all of us. I think I can safely say that some of us have sacrificed greatly to engage in this lawsuit. And we do so because we have every reason to fear the United States government and what it has become since 9/11. We have very specific reasons, and when I approached Chris Hedges and asked if I could bug him and join his lawsuit and perhaps amend it to be a multi-plaintiff suit, I also did so because I was worried about people around me, like Alexa O'Brien, Judith Youngsdaughter, who can't be here today, Kai Warkala, WikiLeaks former staff, all kinds of people. So, you know, what I hope to do with this is create an unorthodox, excuse me, I'm really tired, unorthodox and creative endeavor. That was hopefully to put together the first time lawsuit/campaign. To have what might be a relatively obscure lawsuit just get thrown under the rug or disappear, have support like this, to end up somewhere like this. Because we need to crowdsource truth. We need people all over the world. We need independent journalists who care enough to cover these things, bloggers, activists, civil liberties advocates. This tribe, this evolving tribe that we're a part of, we all play a role in it, we all play a critical role, and it's only together that we're going to actually turn this madness around. But you know what? I'm absolutely convinced, that after today, seeing this, we're going to win. Whether it's this case or not, we're going to win, we're going to turn this around. So thank you for being here. Sorry, I'm so tired. Thank you for being here. I'm so Okay, so I'm going to get started with the first question. So for those of you that either were or weren't in court today, what Mr. Afrin said in a press conference straight after was that the appeals court really honed in on what underpins what's at stake in this case and what the real arguments are. So I was hoping that perhaps Tangerine would best deal with this and perhaps the attorneys present. What exactly was that? And if you could touch a little bit on what's really at stake with NDAA. So I'll just give a quick synopsis and then hand it over to you two. From my research, it looks like the Department of Justice and the administration are going out of their way to deliberately conflate two different laws, very distinct laws with different powers of indefinite detention. These are the AUMF, the Authorization for Use of Military Force from 2001, and the 2012 NDAA. The AUMF covers a very narrow, very specific three classes of people. People who planned or participated in the 9/11 attacks, or members of Al-Qaeda or the Taliban. That's it. However, the 2012 NDAA has that in it and adds another paragraph. The second paragraph is the one over which we're suing because it has this very broad and scary, undefined language such as associated forces and substantial support. Despite that new paragraph, these obviously sweeping new powers, the government has been saying over and over again in our case that these are precisely the same things. They're not the same things. That's patently false. What this looks like and what Judge Forrest called out in her ruling is that it's a retroactive CYA. It's a retroactive attempt to legislatively fix the fact that they didn't have these powers all these years and they were probably using them. So this case is the last in Pandora's box, and it needs to be addressed because what they would like to see is have us be swept under the rug and disappear because we're a threat to the fact that they haven't been behaving well for quite a long time. That's quite obvious. So I'm going to pass it on to Carl and Bruce.
Well, in broad terms, the stakes, I think, are very high because what our case comes down to is, are we going to have a civil justice system in the United States or a military justice system? And the civil justice system is something that's ingrained in the Constitution, and it was always very important in combating tyranny and building a democratic society. And what the NDAA is trying to impose is a system of military justice that allows the military to police the streets of America, to detain U.S. citizens, to detain residents in the United States in military prisons. And I say that probably the most frightening aspect of the NDAA is that it allows for detention, quote, until the end of hostilities. We're now, by my count, day 4,163 of this war, which is an open-ended war against Al-Qaeda, the Taliban, and now it's defined as associated forces in the NDAA. And so this type of militarization of our justice system has occurred sometime in our history. And at the argument today, I pointed to the case of Korematsu, which had to do with the forced internment of Japanese Americans within the United States during World War II. And so we're trying to prevent a repeat of episodes like that. And that's what the case is about. It's really about preserving our civil liberties and our civil justice system in broad terms. I think Bruce might add some more particular formulations of what it is we were arguing today.
Well, there are a lot of technical issues, standing, whether our clients can be in this court. That gets mired down to a lot of things. The government says, well, this is really an old law. The AUMF 11 years ago said the same thing. Therefore, since we haven't arrested Dan Ellsberg or Chris Hedges since then, they don't have to worry about it. And Dan Ellsberg will tell you, what the worry is when these statutes are held over your head. But they're not the same thing. The AUMF talks about people in combat. And sure, someone in combat in Afghanistan or Pakistan might be a suitable person to be arrested in the course of war. But this is something different. It drops out the requirement of being a combatant. It simply says if you substantially support Al-Qaeda or its associates or the Taliban, you can be detained by the military indefinitely. I once tried to run for Congress, and I went to a meeting of the Royal Order of Hibernians, and a member of the Northern Ireland government was going to speak, and they asked for a donation. So I said, well, if I run for Congress, I'm not going to not give a donation. So I gave a donation. I wrote a check as I walked in, and months later, I got back a thank you note and acknowledgement from Sinn Féin. And I was very surprised. I didn't expect to be giving money to a group that maintains a paramilitary terrorist organization, as some people say. And this is the danger, that you can easily find yourself in a setting that the government deems worthy of incarceration. And this is why people cease to speak out. I mean, I am sure the government's not setting up massive internment camps for journalists and activists. But the very fact that these powers exist is what diminishes free speech and the commitment to free speech. And every time we have a law like this, that commitment is eroded further and further downward. And that's what we're fighting against.
And, let me follow that up with you, Chris, since you're the lead named plaintiff in this case. As the government said today, they haven't exactly been going around picking people up in their black vans yet. So,
well, no, they said that wasn't quite what they said. They said I hadn't started driving in black. But if I did, then that would change, and they would pick me up.
So, why were you so scared by this law to start this law?
Well,
why do you think you might get picked up someday?
The origins of the lawsuit come from Carl and Bruce, who needed to find a credible plaintiff who had standing. Because I was a foreign correspondent for 20 years, 7 of those years in the Middle East, I spend significant amounts of time with groups and individuals that have been deemed to be terrorist organizations or terrorists themselves. We went through the State Department terrorism list, and in fact, I've been with 17 different groups, including Al-Qaeda. And there's no exemption in this provision, Section 1021, for journalists. I covered the conflicts in Central America in the early 1980s. I was there for 5 years in El Salvador and Nicaragua, and traveled frequently with the FMLN rebels as well as the Sandinistas. And the rhetoric of the Reagan administration was that they made very little distinction between the journalists who went out and reported on the atrocities that were being carried out by the death squads and the military forces in El Salvador or the Contras in Nicaragua. They regularly lambasted us not only as fifth columnists, but as an integral part of the terrorist apparatus that they were trying to fight. And so I've already seen the rhetoric. I know that it's there. But what this does is a quantum leap from a linguistic condemnation to a legal condemnation. And so, having spent time with groups like Hamas or Hezbollah, and having reported their viewpoints, the statute is so broad that any government official, and I can go back to my experience in Central America, could check that box off and name me as a member of this group, in which case, under this provision, and it is law now, by the way, because although Judge Forrest issued an injunction, the government attorneys went to her the day that she issued the ruling and asked for a stay, a temporary stay, meaning put the law back into effect until the appellate court hears the case. Now, Carl and Bruce and I and the other plaintiffs expected an appeal. What we didn't expect was an aggressive appeal. And when Judge Forrest did not cave to the government's pressure, they demanded an emergency hearing, well, this was on a Friday, at 9 a.m. Monday morning at the appellate court to put the law back into effect. And I think it's fair to suppose that the reason that they needed the law put back into effect immediately is because they're already using it. Because if they were holding U.S. citizens, and I suspect they're probably holding U.S. Pakistani dual nationals in places like Bagram, and Judge Forrest's injunction stood, then they would be in contempt of court. So I've already, I've experienced the kind of pressure the government will put on foreign correspondents who are standing on the other side of the divide and reporting it. And it was immediately clear to me, as it was to Carl and Bruce, that if this was given legal weight, people like me could instantly be locked up and stripped of due process.
And Carl, Bruce, let me kick this back to you for a minute, because during the hearings, the oral arguments today, one of the things that came up was a ruling in 2010 called Holder versus Humanitarian Law Project, where the Supreme Court held that the government can prescribe people who have materially supported terrorist groups. So even if Chris does have reason to fear here, does have standing here, can't the government still prescribe this free speech under that ruling?
Well, the Holder law is really the mouthful, the Anti-Terrorism and Effective Death Penalty Act of 1996, which we also call the AEDPA. And that law creates defined wrongs. Material support is defined as giving financial aid to a terrorist group, sending materiel to a terrorist group, sending weapons, providing weapons training. And there's an exemption in the law for First Amendment activity. Our law, the NDAA, changes all of that. It says if you substantially support these groups, you're subject to incarceration. No definition, and no exemption for First Amendment activity. Now, I said in court, there's a long set of case law that says we take Congress at its word. When Congress speaks in a way that differentiates the law from other similar laws, we have to assume Congress meant something different.
But the group at question in that case, they said, oh, all we want to do is talk to terrorist groups. You know, this humanitarian law project said, we just want to be able to talk, you know, to these Kurdish.
Well, that's not
groups.
exactly what
Okay.
they said. They said they wanted to advise them
Uh-huh.
on their legal rights. And that's a big difference from merely reporting on them, say, as Chris would do, or as Alexa would do when she interviews people. They wanted to advise them on how to protect their legal position. And that's a different animal. I think that's a gray area, frankly. But the court there said that the statute was constitutional because it was sufficiently defined. We have no definition here. And that's a great difference. Carl?
Well, I just quickly, you see with almost each passing year, the government keeps pressing the outer boundaries of who they can target. First it's Al-Qaeda, then it's, quote, associated forces. They're expert in making up these squishy terms like co-belligerents, and they keep expanding the target for the government to the point where now we're involved in military action in Yemen, Somalia, Libya, Niger. It's ever expanding, and that's how the law has been going too. First the outer reaches were at the Holder statute, the anti-terrorism statute, where it was material, and now the NDAA has gone to substantial support, which could be construed as journalism or writing, and so the progression is going in the wrong direction, and it's only if citizens fight back via protest or in litigation that we're going to stop this, because I see no effort by either party to stop this.
You know, to answer your question, could Chris be prosecuted under that law for what he says he's done as an example, or Alexa? They're not doing those things. They're speaking out, they're interviewing people, they're conveying their viewpoint to the world. They're not advising them on how to run their battles and how to protect themselves. So it's a different animal completely. It's a more dangerous animal because their conduct is pure speech. And this statute doesn't exempt speech. It actually allows the government to punish speech. And that's what we're here about.
So in putting together this set of plaintiffs, they're known as the Magnificent Seven, by the way. Sorry, it's fine. Certainly there's a kind of a large amount of journalists that you yourself elect, Mr. Hedges.
Louder, please.
Sorry. But also, we enter into the grey area of whistleblowers and activist supporters. And I was wondering perhaps if Mr. Ellsberg could touch upon how your role historically as a whistleblower seems to relate to this case, and perhaps Alexa too, given that you have spoken at length with groups like WikiLeaks and have interviewed them as a journalist, and whether those implications are. No, you'd rather not? Just Daniel.
Well, reading Judge Forrest's opinion last night, which is well worth doing. I didn't read every word. I went through every word, the 112 pages, and read a lot of it quite carefully because it was fascinating. And one thing that struck me very much was here was somebody actually taking the Constitution seriously and the rights seriously, as though they weren't just a piece of paper, but were really important to interpret and preserve. And it struck me that if Judge Forrest had been a judge, and there have only been a couple so far, who had addressed the law on which I was prosecuted, the so-called Espionage Act, 18 U.S.C. 793, paragraphs D and E, corresponding to this section. I can roll that off trippingly now after 40 years. And that she would almost certainly, I would think, find that unconstitutional and facially unconstitutional. And again, the same issues arise. Breadth and vagueness in this case. The word classified isn't used in that, by the way. They talk about information relating to the national defense, which is obviously as broad as you want to make it. Altogether, for practical purposes, they've tended to apply it to classified information. But that in turn is in a vastly inflated, enormous amount of discourse that's covered by this and not appropriate. The way that act is written, it can apply just as well as to me or Bradley Manning and all of the 6 cases in which it's been invoked here. It can apply exactly as well to a reader or to an editor or to a journalist. No distinction is made. It says if you receive classified, it doesn't say classified, information relating to the national defense. and do not return it to the proper authorities. For example, your New York Times said we cannot tell you the source of this because it's classified, and you're looking at it, you've been told it's classified. If you don't return that paper to the proper authorities, who would be, you know, exactly who in this case, and if you hand it to your spouse, you are, that's the second, you're not only possessing it, you are delivering it to someone not authorized to receive it any more than you were. Well, words like that mean that literally, as far as the words are concerned, everybody here who reads a classified document in the New York Times, and certainly the journalists, can be prosecuted under that. And obviously, a breadth aspect there and vagueness that's enormous. Well, that's never gone to the Supreme Court. The Supreme Court has never ruled on that. That law should be found unconstitutional. I'm saying the provision under which Vaughan has now brought actually 7 indictments. Usually say 6, but there's a quiet one just a couple months ago. And of course they're working on Assange. If any of those could lead to convictions and are sent to the Supreme Court, and in the past, 3 people out of these 7 or so have pled guilty, whether they should have or not. A very questionable one, but to get out of the case, they pled guilty. There's been no, except for Franklin Morrison, Samuel Loring Morrison. He was judged by a jury. He's the only one who's been judged. That case did not go to the Supreme Court. The effect of it was denied. The effect was the Supreme Court has never ruled on whether it is in fact criminal to release to an unauthorized person, that is a cleared person that doesn't have a clearance at the moment, among other things, any information they've protected, any classified information, anybody you're holding in your hands. Now, they can say, we haven't applied it to you, don't worry about it, trust us. Isn't that exactly the same thing that's arising in this case?
They're saying, we're choir boys, we don't want to affect journalists. Yet then they'll say, independent journalists have nothing to fear. But who judges who's independent?
Yeah.
And that's the great problem. There's no such thing as independent speech.
So if in the case of 18 U.S.C., if they turn it on Assange, there's a case where he could, a lot of journalists, maybe even Bill Keller will say, well, he's not really a journalist. We don't have to worry yet. We can't be in solidarity. We don't trust this guy. He's not a real journalist. That's why he offers them a very good target, a gray area. If Assange were indicted and convicted, he's doing exactly the same function as the New York Times or the Post. There's no real distinction, except that the Post and the Times may not notice it. And in which case, they'd be going after others as well. Same here. When they asked me, for instance, is yours, the lawyer asked me, is your speech, public speech, going to be chilled by this act since you're supporting WikiLeaks? Now, WikiLeaks and Manning Manning specifically, has been charged with aiding the enemy. That sounds very much like a group associated with an enemy group.
Well, their general view is, well, if the world learns of some of our embarrassing dilemmas, like shooting innocent people in different countries, that's aiding the enemy because the enemy, is more emboldened to keep fighting. Well, that's a very disconnected concept. But once you take that standard, nothing is sacred. Every journalist in the country.
Okay, so I'm aiding an enemy, I'm aiding WikiLeaks. Then they come after me, and I say, well, if they're going to stop me from talking in favor of Manning, my first thought was no. The lawyer then said, well, sorry, then, you don't have standing, because if you're not hurt by this, if you're not affected by it, you don't have standing.
Yeah.
What's it?
Sorry, go ahead.
My second thought was, wait a minute though, I don't mind saying what I say in public. Everybody knows what I've said, they can judge it for themselves. Might be found guilty, but at least the public would know what I'd said and what I haven't said, and could make their own judgment. Since NSA and FBI are listening and recording to every word I say on the phone and in text and in email, they all have that. I don't like the thought that they can put me in military custody without the public even knowing what the context was that I said. Maybe they wouldn't even have to tell me. I don't know, you can tell me. They said, we've heard you say this, that to us is support. They might or might not tell me, it's classified. They can't tell me. But in any case, they can come out and get me for talking to these people without it being public, what it is I've actually said, or what is the context. So it seems to me there are people right in this room that I would phone a lot, literally, that I would phone a lot more than I am if I could be sure, A, that they're not listening to me, which is impossible, and second, that they're not going to use it against me to put me in military detention. That I'm not anxious to do.
And I'm curious to hear from, the other